May 19, 2012. It's Justice Under Cheap. Just giving you a perspective of what it looks like traveling by night, city of Fredericton. I want to talk about justice and how Black's Law Dictionary defines justice as a fair application of laws. And judges have a duty to apply the law fairly to everyone who's in front of them. They have a duty to understand the argument that's placed before them. And if they don't understand, then they need to ask questions so they can understand. Without understanding, there can be no judgment. One should not be deprived of justice because a specific judge does not understand their argument. And I spend a lot of time researching and preparing for hearings whenever I'm in court. I do a lot of research. I try to give the judge every opportunity possible to find in my favor. And I think one should try to do that. Give the judges every opportunity to find their favor. Give them lots of options that they can choose. Options that you've decided are in your interest. And argue them. Now I'm going to give a basic example of some procedure that you may not be aware of. And I'll take an example of a motion. When one files a motion to the court, they're basically asking the court to do something for them. They're motioning, they're waving, saying, "Hello, can you do something for me?" And in the motion, I believe it's Form 37A for Court of Queen's Bench Trial Division, one puts in the relief they're seeking, which is the orders they ultimately want the judge to authorize. Then they put the argument that one is using, the real bare bones argument, so that everyone who served the motion knows where you're coming from, what your legal position is. Now what I do is whenever I'm filing a motion, there's an affidavit that goes in support of that motion, and the affidavit is swearing the facts that are relevant to the matter. If one is asking for an extension of time for service, they have to state what the original deadlines were, why they missed it, what their reason for the delay was, and any other relevant material that the judge should consider, because if there's any facts you want the judge to consider, one has to provide it by affidavit, and one should substantiate their written position with as many exhibits as in copies of contracts and such, copies of receipts, copies of documentation that substantiates one's legal position and the storyline one is presenting to the judge. So to start off, one has a motion, Form 37A, and in that motion there's the relief they're asking the court to provide, which is the orders. Then there's the basic legal position, which is the bare bones few paragraphs to explain why the judge should rule in favor of the moving party being the one who's authoring the motion. Then There's the affidavit, which provides the facts, the factual basis that one wants the court to consider. This has to provide the who, what, where, when, and why that the court needs to know before granting relief. One should be as detailed as possible, providing dates, times, and then when one is providing a brief, one takes see, a brief has several portions to it. One of the part is statement of facts. The statement of facts is basically a summation of all the affidavit material that was provided to the court. The real basic stuff, so the court basically doesn't have to reread the affidavit material. They only read the statement of facts. Then one gets into the argument, which is basically an expansion of the basic argument and legal position one had placed in the motion. The difference is it's expanded out, and one would start off a section with basic a question: should the court grant relief A? As in, should the court grant an extension of time for service so that whatever deficiency could be cured and the matter may be heard on its merits? Now, the reason for the question is if the court answers in a positive, then the court should grant one of the orders that a party is seeking. If the court answers that in a negative, then one's not going to get the orders they're seeking. So the idea is one is supposed to convince the judge through written argument, case law, and authorities that cite one's legal position and backs up their legal position. And this isn't any real special formula to it. One is trying to convince, forget that it's a judge, just think, at least I think, I'm trying to convince a reasonable individual. So what do I need to say to convince a reasonable individual who is being brought up to speed on the facts of the matter, and then given all the legal argument that supports my legal position? At the end of the whole argument, should a reasonable person agree with my legal position? If I argued it well, I would hope so. If I did not, then they may not agree. So that's the basics of a brief, and the brief is an expansion on the motion, like I said. And what's interesting is in the brief one has an opportunity to quote common law or case law. And what one must consider is that if one is quoting another judge, a judge of equal jurisdiction, as in if you're before a Court of Queen's Bench, a New Brunswick judge, and you're quoting a judge of Court of Queen's Bench, showing the judge you're before that the previous judge had ordered in a similar circumstance in your favor, and the judge should find in a similar fashion. That's what makes our Canadian legal system the way it is. Basic precedent and case law. Now, if you find a decision from a higher court, that is known as a binding precedent, as in it's actually, the judge cannot rule differently because he cannot go over a judge of higher jurisdiction. So what ends up happening is one tries to get as much of their legal argument and authorities from higher courts. When you get it from higher courts, the judge is bound to rule in your favor. If they don't, they're committing an error in law, and that is known as a reversible error. So, These are some basic ideas for consideration regarding preparing a brief for a judge to consider and to rule in your favor. One tries to, and the authorities one can rely on are authors, other judges' decisions of the same jurisdiction or other jurisdiction. One can present argument from United States judges. If one is in Canada, they can present an argument from our cases that were in the US or other jurisdictions, because a judge is supposed to consider it anyway. If the decision makes sense, it's reasonable, then why wouldn't the judge consider it? Other places one draws authorities from is dictionaries. I rely heavily on Black's Law Dictionary. I find it's a very good dictionary. It's great for defining legal words. I provide a lot of definitions so the judge is not under any uncertainty about what the meaning of the words I'm using are. So I provide a lot of definitions for words. I even compare Black's Law Dictionary definition to Merriam-Webster or other Canadian legal dictionaries to present my case. So, and the highest decisions one can refer to in Canada would be the Supreme Court of Canada. So if one can find a decision from the Supreme Court of Canada that the court found in your favor, even if it's a split decision where 4 judges went one way and 5 judges went the other, even if it's a dissenting opinion, that opinion still carries a lot of weight and should be considered by a lower court, and that is binding precedent. So these are things to consider. Writing a brief for a judge is pretty straightforward. You're trying to convince just a reasonable person that's brought up to speed on the facts to be brought over, to be convinced to think like you're thinking and to find in your favor. So that's all for tonight. It's Justice Done Dirt Cheap in Fredericton, New Brunswick, just sharing some thoughts on some basic procedure, taking a basic motion and expanding it off into a brief to support that motion so a judge finds in their favor. Thanks for listening and have a good evening.